Good afternoon, everyone, and thank you for joining us today. And thank you for giving us a minute here so that everybody could load into the webinar. It's been another busy legislative session in Springfield, and we are pleased to share some of the legislative changes that will impact K-12 public schools in the near future here. I'm James Petrangaro, and Emily Tolick joins me to bring you these legislative updates today. Emily is one of our senior associates at Franzik, and she plays a vital role in keeping our clients up to speed on the charges coming from our elected legislators. We only have 30 minutes with you today, and we have a lot to get through. We may go over by a few minutes, so if you can, please continue with us past 12:30. And before we get into the bills that were recently passed, we want to talk about some of the significant legislative pieces that had been proposed but did not make it to the governor's desk this summer. There was a bill that aimed to bring relief to public bodies who received FOIA requests through artificial intelligence programs. Unfortunately, that did not pass both houses. And neither did a bill that was pushed by the teacher unions that would have chipped away at the efficiency of notices to remedy that are given to teachers who have attained tenure. That bill, or at least proposed bill, had aimed to unravel 30 years of Supreme Court precedent, and that did not pass. But we do foresee that we may see a revised version coming back in a future legislative session. And there was also a proposed piece of legislation that would have eliminated the application of the Cook County paid leave ordinance to schools. Many of you are familiar with the Paid Leave for All Workers Act in Illinois that had been passed a year ago that had exempted school districts and park districts from the reach of that law, and then Cook County brought their own ordinance. The bill that would have eliminated the application of county ordinances on that subject did not pass out of the houses. So the Cook County paid leave ordinance does still stand as good law in Cook County. So what did come out of the two houses of legislature? Let's get into that. But first, we of course have our lawyerly duty to give you a bit of a disclaimer or a caveat. Many of these bills are still sitting on the governor's desk. So while they are likely to be signed into law, the governor could still veto them. Unless the bill is marked in our slides here today as a public act, it's subject to a possible veto. So we'll stay tuned on those bills. We also want to let you know that we'll be sending out these slides to you later this afternoon. And then once these bills are signed into law, we'll be sending a detailed legislative update alert out via email. So if we move too fast today, don't worry. You'll be getting the details on these bills as long as you're signed up for our alerts. If you're not receiving alerts from us, you can sign up at franzik.com under our thought leadership page. So first up today, we have Senate Bill 1947, and this is a bill that addresses requirements for teacher preparation for those who are seeking teacher licensure. It exempts those who are seeking a Pell with a school support or CSBO endorsement from the following requirements: coursework in psychology and identification of or methods of instruction for exceptional children, including those with learning disabilities, as well as coursework in methods of reading and reading in content area. This bill also requires the state board by July of 27 to incorporate the topics of methods of instruction of the exceptional child, methods of reading and reading in content area, and instructional strategies for English learners into the requirements for those seeking a Pell endorsed in teaching or administration, but excluding CSBOs. Those who are seeking a Pell, except those who are seeking school support endorsements, who already hold an active and valid professional license that's issued by the Department of Financial and Professional Regulation. So these tend to be professionals that have experience in the field, are required now to take a test of content. Yes, they are required to take a test of content area knowledge for each of the area of endorsement that has testing requirements. All right, next up, Emily, is Senate Bill 28. This is a bit of a significant change to how teachers are to be evaluated. And if you're at all involved in teacher evaluations currently, you know that about a decade ago, landmark legislation known as PARA made it mandatory that teacher evaluations include student growth as a significant evaluation in teacher ratings. I'm sorry, a significant factor in teacher ratings for their evaluations. And following PARA, ISB implemented regulations to set forth how much of that evaluation formula must include student growth. That is all now changing, or at least it's subject to change starting July 1 of 25, so just next month. Now it is going to be no longer mandatory that teacher evaluations include student growth factors as part of the evaluation formula. Many of you are familiar with the para committee process where annually your evaluation tools and documents have to be reviewed. You all have evaluation tools and documents right now that mandate student growth. It is still permissible to include student growth as one of the factors in the evaluation tool. It's just no longer mandatory. So if you prefer, your district can make changes to your evaluation documents and your evaluation tools. You'll have to do that through that para joint committee. There may be aspects that impact collective bargaining with your unions. Many of your collective bargaining agreements incorporate the evaluation documents into the CBA. So there's a whole process that will be required to modify your evaluation approach with teachers. But going forward, it's no longer a legal mandate for schools to require student growth to be part of that evaluation process. Next up, we're going to talk about Public Act 102-466. This is a law that maybe you can tell here because it has that public act from a couple legislative sessions ago that has been on the books for a few years. This was the Ensuring Student Success Act that created Article 26A of the school code. It was passed back in 2021, kind of at the peak of COVID, but the requirements of that act were not to be effective until July 2025. So this is a reminder that that act is now going to be effective in just a few days here. And that law outlines how the occurrence of four particular issues, and those are students who are parents already themselves, who are expectant parents, are victims of domestic or sexual violence, are to be provided supports to stay in school and be safe and to succeed academically. Part of that law requires that school personnel play a role in complaint resolution. We now have a bill that is sitting on the governor's desk that amends the act that is not even effective just yet. The act had called for a minimum of 8 hours of training or 6 hours of training from those who are going to be part of the ESS complaint resolution requirements. Senate Bill 1740 now removes those minimums and just simply requires that training be provided. So there is some relief as to the length of the training, but training in general is still required. That bill does not specify an effective date. If it's going to be signed by the governor, it will become effective on January 1 of 26. So there's approximately a half a year that law will be on the books, that those training requirements will be technically required using those hours. But I think the spirit of the law, once it's signed, is that would not be enforced.
So let's move on to some student issues. We talked about some of those more labor and employment focused bills that have passed through both houses. Switching over to some of the student issues side, this is the first of two bills we're going to talk about that relate to special education. So this is House Bill 2337, and this essentially ends up amending the Section 14 of the school code by adding language that limits waivers of future claims in due process, mediation, resolution, or settlement agreements to certain situations that satisfy the requirements you see here on your slide. So any waiver of future claims has to be limited to the student who's the subject of those proceedings. The waiver can only be related to the claims raised in the complaint. So, for example, we can't have a general release of all future claims. It has to be related to those issues that are, before you in the due process proceeding. And the waiver has to be for a reasonable duration of time. Uh, I know when this bill was first introduced, there were some concerns swirling in the education community because when it was introduced, it really prohibited future waivers of all claims related to the provision of FAPE or a free appropriate public education. By the time this bill passed through both houses, that those requirements were reduced significantly to what you see here on your slide. So much more manageable when we're writing those special education settlement agreements. Um, it is interesting that this was passed through both houses because generally in Illinois, we can't waive future claims. And this bill explicitly allows that to occur in agreements resolving special education disputes, as long as these factors are met. This is our second special education related bill that we saw pass through both houses during this legislative session. And this allows school districts to initiate due process proceedings within 7 school days of a parent's request for an independent educational evaluation or an IEE. For those of you practicing in special education more frequently, you might recall that this was currently this is a 5-day requirement. So this would extend that timeline to 7 days. This bill also states that the IEE would need to be completed within 60 school days as opposed to 30 of the parent's request. So it gives school districts additional time to complete those IEEs. And finally, the bill states that if a due process hearing decision indicates that the parent is entitled to an IEE, then it must be completed within 60 school days, again, rather than 30 of that hearing officer's decision. Notably with this, I put an asterisk here under number 3 and the 60 school day requirement because there is a provision in this bill that allows an extension of that 60-day period if the parent or the school district offers reasonable grounds for it to be extended. So there is a little bit of wiggle room in that timeline as well.
So we saw a few bills come out of this legislative session that focus on the role of law enforcement in schools. And just to speak to a little bit of the background on this, before Senate Bill 1519 was filed, there were reports finding that police issued nearly 12,000 tickets to students between the years of 2019 and 2022. Many of you saw extensive coverage from ProPublica in the Chicago Tribune about tickets that were being issued to students and the disparate impact that the involvement of law enforcement and either criminal citations or municipal citations that were being issued to students, the disparate impact that that had on students of color and other disadvantaged backgrounds. So growing out of those investigative reports, growing out of the involvement of the Attorney General's office in investigating a large high school district in the Chicagoland area, we have Senate Bill 1519 that was filed. It defines what a referral to law enforcement is, and that includes any action in which a student is reported to a law enforcement agency or official, including school police units to the extent your district might have its own police unit, for incidents occurring on school grounds, during school-related events and activities, whether schools in person, as we're back to, or if there is any virtual aspect of the education, as we see from time to time nowadays in lieu of what used to be snow days or inclement weather days, or actions that take place during school transportation. That's the jurisdiction in which referrals to law enforcement apply under this bill involving schools. It includes any referrals that seek citations or tickets or court referrals or school-related arrests. So it has a very broad application in the school setting involving the involvement of law enforcement. Starting with the 2027-2028 school year, ISB is required to collect data from school districts on the number of students between the K-12 levels that are referred to law enforcement. Many of you saw FOIA requests in the last year that was seeking this data. Some schools maintain the data. Some schools had accessible data at their fingertips. Others had to search for it. Now ISB is going to be requiring that that data be uploaded by school districts on an annual basis. And then ISB is going to be preparing a report as is required under the law here, beginning in January of 2029. And ISB is to post their report on the number of referrals that are made to law enforcement on their websites. This Senate bill also, once it becomes law, will prohibit monetary fines or fees, tickets, or citations to be given to students as a school-based disciplinary consequence or for municipal violations. So if a student has a piece of misconduct at school, it can no longer be that law enforcement provides some sort of fine or ticket or citation as a basis for a law enforcement action against the student if the activity happened during the school day or within that jurisdiction that we discussed before. Of course, if there are issues that happen away from school, issues that would typically be covered by the juvenile authorities, that is still protected, but law enforcement and municipal authorities can no longer issue citations for actions that happen at schools. That same Senate bill also addresses SRO agreements, our school resource officers. Many of your districts engage a school resource officer. You most likely have an intergovernmental agreement with the local municipality or the local police department. Beginning July 1, 2026, a memorandum of understanding or that IGA is now mandated if you're going to engage the services of a school resource officer. And as you can see on the slide there, that agreement must include provisions that define the SRO's roles, their duties, their responsibilities, specify procedures to make sure that the SRO has been trained. Illinois law requires that any SRO providing services to school districts be specially trained as an SRO. That's now going to be required to be a provision in your agreement. There must be a provision in the agreement that prohibits that SRO from issuing tickets, as we just discussed. And then your SRO agreement also has to address a process for data collection and reporting to the State Board of Education pursuant to the reporting requirements we just spoke about. And then finally, there has to be regular review and evaluation of the SRO program and that agreement with the local authorities. Finally, Senate Bill 1519 addresses truancy. It makes a bit of a technical change to the school code. Previously, the school code read that a school district could not refer a truant, chronic truant, or minor truant to an SRO or law enforcement. The legislature has seen it fit now to change that to prohibit school personnel. Our assumption here is that there were some arguments that if a school district was prohibited from making that referral, that must have meant some sort of official action by the corporate authorities, by the Board of Education, and therefore employees of the district still make the referral. The legislature has clarified that, and nobody working for a school district may refer a student to law enforcement for being a truant. This does not change the provisions of the school code that allow schools to make referrals of parents of truants, students who are not attending school. It's just that the students themselves may not be referred to law enforcement. And so that's that change.
Okay, switching gears a little bit to curriculum and some of the bills that are in that area. You're going to see here a lot of slides that have to do with Senate Bill 1740. James already talked about one of the components of Senate Bill 1740, which is that comprehensive training requirement for complaint resolution. And you'll see that there's been a lot packed into SB 1740, a lot of which doesn't really relate to each other. So there's not really one topic that this bill is on, but there's been a lot packed in here. So the first is a new section of the school code that requires all public schools to have instruction and discussion with students about recognizing the danger of and how to avoid abduction. It does not include any parameters for what this education has to include beyond the general concepts of, recognizing the dangers of abduction and how to avoid abduction. I'm hopeful that we'll see some more guidance in that area should this bill be signed by the governor. Also under 1740, it creates the Critical Health Problems and Comprehensive Health Education Act. If you've been in schools for the last couple years, I think you'll recall that we kind of get a change in these like health curriculum objectives every couple of years. So this is kind of our newest phase of the comprehensive health education programs in schools. It provides that the comprehensive health education program has to be provided in all elementary and secondary schools, and it has to include consent education and instruction on mental health and mental illness. The bill does define comprehensive health education program and consent. Interestingly, I'll just note that consent is defined under the bill as an affirmative, knowing, conscious, ongoing, and voluntary agreement to engage in interpersonal, physical, or sexual activity. And the act also states that consent education does have to be age and developmentally appropriate. So thinking about the fact that we do have to include these topics in all comprehensive health education programs starting at the elementary school level. It also states that the required comprehensive health education program in all elementary and secondary schools has to include all of the topics that you see here on your slide. I want to highlight specifically the prevention and control of disease, including instruction in grades K through 12 on the prevention, transmission, and spread of AIDS, and age and developmentally appropriate sexual abuse, abuse during pregnancy, and assault awareness and prevention in grades pre-K through 12, as well as that age and developmentally appropriate consent education. Again, I think these are some of the areas where we might see a bigger shift in some of the curriculum, particularly at those younger grade levels where we might not have been discussing some of these topics before. The bill also allows basic first aid to be included in health education for grades 7 through 12, but it is not required. And it does allow parents to opt out of classes and courses that discuss AIDS, family life instruction, which is unhelpfully not defined, and training on properly administering CPR or an automated external defibrillator. So if a parent does submit an objection or an opt-out for one of those courses, then we have to permit that as a school district and can't discipline the student for not being engaged in those topic areas. SB 1740 also requires under that comprehensive health education provision that ISB and DCFS both prepare and disseminate instructional materials and programs about child sexual abuse to all schools. Schools may disseminate that information to parents, but it's not required. ISB is also required to establish guidelines, programs, and training to effectuate the requirements of this comprehensive health education provision of SB 1740. So I'm hopeful that once ISB comes out with some of that information, we'll have a little bit more guidance on how to integrate a lot of these concepts into curriculum that you already have and what that'll look like. It also creates an advisory committee of 11 members to advise ISB on implementing the act, and it requires ISB to develop a nutrition and physical activity best practices database, which does not require school district reporting, but again, another one of those resources that schools can use. Moving on, SB 17, still under SB 1740, but moving on from the comprehensive health education program portion. It does require all secondary schools to include training on how to properly administer CPR and use an automated external defibrillator or AED in grades 9 through 12 curriculum. The training has to be in accordance with the standards of the American Red Cross, American Heart Association, or another nationally recognized certifying organization. Again, here, no student is required to receive that CPR or AED training if a parent submits a written objection to those. SB 1740 also discusses allergy instruction. So it requires that 9th through 12th grade curriculum includes instruction on the dangers of allergies. That information for the instruction has to come from the Department of Public Health and the CDC. And then it establishes requirements for the curriculum, which you see here on your slide. So at a minimum, recognizing signs and symptoms of allergic reactions, preventing exposure to allergens, and safe emergency EpiPen administration. SB 1740 also requires all public schools to have, at K through 12, to have instruction provided by a teacher, nurse, social worker, counselor, or law enforcement officer on sexual abuse prevention. So the topics differ by grade level, and you'll see the breakdown here on your slide. But for example, kindergarten through 4th grade, the bill requires annual instruction on effective methods for prevention and avoidance of drugs, as well as the dangers of opioid and substance abuse. Once students kind of reach that 5th through 12th grade level, the instruction should include alcohol and drug use and abuse, including the physical and legal effects and ramifications of drug and substance abuse. Moving to 6th through 12th grades, the instruction needs to include the dangers of fentanyl. As we get to the 9th through 12th grade level, again, we see that requirement to include instruction on the dangers of fentanyl, including information on fentanyl itself, including an explanation of the differences between synthetic and non-synthetic opioids and illicit drugs, variations of fentanyl, and the differences between legal and illegal uses of fentanyl. Side effects and risk factors of using fentanyl, and information comparing lethal amounts of fentanyl to other drugs. Students in grades 9 through 12 also have to be assessed on the dangers of fentanyl. And then if we look at grades 7 through 12, the bill requires instruction on preventing the abuse of anabolic steroids as well. For all of these, your school board is responsible for determining the minimum amount of instruction to comply with this provision or this bill. Again, we see a requirement that ISB has to develop and make instructional materials and guidelines available to assist schools with incorporating this instruction requirement to existing curriculum. So I know there's a lot of requirements that are kind of being thrown at you, and you might be thinking, well, where does this all fit? Do we, is there something that extends the school day? No. And hopefully we're going to see some guidance from ISB here that helps incorporate a lot of these topics if you aren't already incorporating them. Still under SB 1740, the new school code, it creates a new section of the school code regarding online safety and media literacy. So it requires all public schools to adopt curriculum for online safety instruction for students in grades 3 through 12, starting during the 27-28 school year. And that should include annual online safety instruction to students in grades 3 through 8, and annual media literacy and internet safety instruction to students in grades 9 through 12. Again, here we see a requirement for ISB to prepare instructional resources and professional development opportunities in order to support this instruction. One of our last topics under SB 1740 is a provision of the bill that requires public schools to include at least one semester of civics education in 6th, 7th, or 8th grade. That instruction has to include a discussion of current societal issues, service learning, simulations of the democratic process, and instruction on the method of voting at elections. Instructional time dedicated to civics under this provision of the bill has to equal 1 hour of each school week, or an amount of time total to 1 hour per school week through the year in these grades. It also requires instruction on American patriotism and the principles of representative government, including the Declaration of Independence, the U.S. Constitution, and the proper use and display of the American flag. I know a lot of you already provide this type of civics instruction, especially when we're teaching towards students taking that U.S. Constitution test or exam. So a lot of this might not be new, but it's now going to be an additional requirement that's included in the school code should this be signed by the governor. I'll also note that the bill requires the Pledge of Allegiance to be recited each school day by elementary and secondary school students. The wording of this requirement is a little bit in conflict with other areas of the school code and Illinois case law, which state that students are not required to recite the Pledge of Allegiance. School districts are simply required to initiate that pledge each day. So I would anticipate that this will be enacted and will, our recommendations will be the same in terms of making sure to play that pledge every day and initiate the pledge, but not necessarily requiring students to recite the pledge each day. Quickly here, House Bill 3026 creates Article 14D of the school code, which relates to dual language education. And the goal is to establish and expand dual language programs across the state. It primarily directs ISB to engage in certain actions and does not require anything additional on the part of school districts. But you'll see here some of the timelines for those requirements for ISB. And last in our curriculum piece is SB 1672, which relates to literacy screening. So this bill is intended to identify students who are potentially struggling with reading so that they can receive early intervention. So this requires that on or before the 30th day of the 26-27 school year, school districts serving K through third grade students report information to ISB related to what early literacy screeners are used by the district in K through third grade, the grade level of students who are administered the early literacy screeners, and the frequency with which those early literacy screeners are administered to K through third grade students. ISB is then required to file and post a report outlining that data that's received. And interestingly, this act is going to be repealed on July 1st, 2027. So we do it once and there might not be any further requirements after that. Moving on to our last couple bills here. I want to talk about SB 0191. I know a lot of our school districts do purchase their own school buses. So for those of you that do purchase your own school buses, any school buses purchased after July 1st of 2031 have to have a combination pelvic and upper torso safety belt system that are in good working condition and meet applicable federal standards. This bill does not require school districts or employees, transportation providers, your bus aides, to ensure that the safety belt is correctly adjusted or that a student is wearing the safety belt, or to provide instructions on how to adjust the belt. It just requires that any school bus purchased after this time does have those safety belts included. SB 1740, our favorite, also requires each school board to adopt a policy regarding teen dating violence, including those topics that you see here on your slide, that it's prohibited, that their school district has procedures for responding to incidents of teen dating violence, who you can report teen dating violence to, and a mechanism for notifying parents and students of that policy. Again, this is something that you probably already have, and so compliance, if this bill is signed into law, is not going to be that big of a lift, but something to be aware of.
Great, folks. Thank you for joining us. We know we're over our time. We just have two last quick pieces of legislation to update you on. And the first is Public Act 103771, which applies to school board training. Your school board members have to, in the first year of their election to office, complete professional development and leadership training within that first year of office. Historically, that required them to be educated on education and labor law, financial oversight and accountability, fiduciary responsibilities, and trauma-informed practices. We now have an addition to that list thanks to this law, which was effective earlier this month. The list is expanded to include improving student outcomes, a rather broad subject that is largely undefined within the law. It simply requires that the training on improving student outcomes has to include information that's relevant to and within the scope of a school board member's duties. So we expect that our friends at the State Board of Education and the Illinois Association of School Boards who provide this kind of training are going to understand what that means and put together a nice curriculum related to those. The law also requires that the school board training, that PDLT training that we discussed, must be provided by either a statewide association that trains school board members or that has been certified by a group that has been certified by the State Board of Education. Historically, the law just said it may be provided, which apparently was ambiguous, and some folks in Springfield disagreed with who was providing that training. And our final bill that we're going to our law that we're going to discuss today, because this is Public Act 103-837, is environmental education, beginning not this school year, but for the 26-27 school year. Public schools must now provide instruction on climate change. So all of those curriculum pieces that Emily just went through, we have another addition to that. And climate change instruction must include identifying the environmental and ecological impacts of climate change on individuals and communities, as well as evaluating solutions for addressing and mitigating the impact of climate change. So we see a codification of climate change education into our school systems here. We know we went over, it's 12:38. Thank you for staying with us if you were able to. Emily and I will make sure to get these slides out to everyone who joined us today. And as we mentioned, in the coming weeks, once the governor signs these bills into law, or if he vetoes them, we will be sending out a legislative update through our alert system. So be sure to look out for that. Thanks so much and enjoy your summer. Bye.
Thanks.